who is here participating. And if you just got the recording in progress reminder, I'll let everybody know that we are recording this. So thank you for your consent to that. So we are here to honor and recognize Stephen J. Ware for the Distinguished Professor, and this is his inaugural lecture. Again, thanks to everybody for joining. It's in honor of one of our newest standout scholars, and I would be remiss if I didn't recognize all of those who do the work of evaluating dossiers and making determinations and supporting our distinguished scholars. So thank you to all who provide support and who do the work of this important recognition. And you can see the presenting slide in the title of Professor Ware's presentation there. I think we all know whatever else is going on in the world, that there's not a day that's going by right now where we don't see the importance of our court system. It's not making the news or that we're reading about something in our social media feeds. And no matter, again, where anybody stands on that, we cannot deny the impact of court rulings and judge decisions and just the impact on our life and our quality of our experience. We are fortunate at KU to have a scholar in our midst who helps analyze and evaluates the circumstances surrounding judicial decisions and opinions, and who also does important work around alternative resolution or alternative dispute resolution processes. So I again want to recognize Distinguished Professor Stephen Ware. He's cultivated expertise in this realm of lawmaking and the work of judges. And we want to thank him for his willingness to be at KU for 20 years. I think that's about the length of time. Is that correct, Stephen?
Exactly right.
Stephen's scholarly interests include judicial selection, alternative dispute resolution, processes such as arbitration, mediation, negotiation, commercial law, including contracts and bankruptcy. And he's taught at 6 law schools, which is a remarkable feat in and of itself. Including Stanford University's Cumberland School of Law, where he was a faculty member for 10 years before he joined KU. Outside the classroom, Professor Ware is actively helping KU Law students as the coach of the KU Law Bankruptcy Moot Court team, and he's a faculty advisor to the KU Law chapter of the Federalist Society. Before entering higher education, Stephen served as a clerk for the late J. Daniel Mahoney on the U.S. Court of Appeals for the Second Circuit. And he was also in private practice with the New York firm of Davis Polk and Wardwell. Stevens testified before the United States Senate and the House of Representatives in front of state legislatures, and he's been an expert witness in court, and all for very good reason. He's the author of 4 books, 46 law review articles, and many other publications. His writings have been cited by the U.S. Supreme Court and cited by at least 34 other federal and state 34 other federal and state cases. He's an elected member of the American Law Institute, which is an honor, obviously, in its own right. And he served on the editorial board for the Journal of Legal Education and as an arbitrator for the American Arbitration Association. As a student, Stephen's academic path included some impressive waypoints as well. He earned a bachelor's degree in American History and Political Science, cum laude, from the University of Pennsylvania, and he attended the University of Chicago Law School, where he earned a Juris Doctorate with honors, and where he served as an associate editor of the University of Chicago Law Review. So we're pleased that Stephen has found his home at the University of Kansas. So please help me welcome Stephen as the Frank Edwards Tyler Distinguished Professor of Law at the University of Kansas. So Stephen, thank you again for being here, and for congratulations to you for this honor. Worthy and well-deserved. And as I understand it, you will be presenting for about 45 minutes or so, and then we'll have about 10 to 15 minutes for questions at the end of the presentation. So we'll hand it over to you.
Thank you so much. I really appreciate it. I'd like to keep this friendly and relaxed, so I hope you'll all call me Steve. And if there's any tech problems, you can put those in the chat and we'll try to get it straightened out. We'll have time for questions, as the provost mentioned, so I hope you'll save those for the end. And what you'll see here is inaugural lectures, because I have learned a ton from other distinguished professors here at KU giving their inaugural lectures, and it's been tremendously broadening for me. I've learned about everything from philosophy to pharmaceutical chemistry, and that's just the field starting with the letter P. What those lecturers did that was so good was they translated their research and scholarship into basics that could be accessible and understood by outsiders to the field. So that's my goal here as well, to take some topics that have interested me and other lawyers and scholars and to try to make them easily accessible to people who are not lawyers or not familiar with this material. And that includes people who are not here with us now on this Zoom, but who may watch this recording in the future. So in trying to make this presentation accessible to a wider audience, I focused on one topic that necessarily excludes lots of the scholarship I've done over 30 years. So I'd like to give just a very quick flavor of some of those things I've written that I won't be talking about much in my main presentation. And here's a list of 5 articles I've written. And you see the first 3 very technical articles. Security interest, farm tractors in Kansas, another one about security interests, a recent one about executory contracts in bankruptcy. And all of those are examples of articles that I've tried to write for practicing lawyers, at least as much as for scholars. Because law school is a professional school rather than a PhD program, I think it's appropriate that law professors' writing can range from very theoretical to really the nuts and bolts of what practicing lawyers are doing. And security interests are not the sexiest topics, so although there may be a couple of people here that would be interested in a presentation about them, I've tried today to pick a topic that would have a broader interest. And next on this list is an article that might have broader interest, ADR in cyberspace, something I co-wrote with Ohio State law professor Sarah Cole, who's here with us today. And Sarah and I could probably have a really interesting discussion about how this has changed with technology in recent years. And many of you might be interested in it, and we might even be able to connect it with this other article I've written, Glucose Model of Mediation. But it would just be too much to try to squeeze into this presentation. So I have to exclude mediation and security interests and bankruptcy, all things I've written on. But if anybody wants to talk with me at some future time about any of those things, I'd be more than happy to do it. So instead, I'll turn to the roadmap of what I do plan to talk about today. You see my title is called Lawmaking Judges, Government and Private. And here are the 6 points that I intend to make. First, that judicial lawmaking is routine, even inevitable. Second, that judges' ideologies influence the content of the law judges make. Third, that the importance of judicial ideology is why we in our society battle over the 3 methods of selecting government judges and the particular selections within them. And you notice I use the phrase government judges because the 4th point I'm going to make is that we also have private sector judges. We call them arbitrators, and the method of selecting those judges is contract. Then the 5th point is that judicial selections tend to reflect power under the applicable selection method. And then finally is an open-ended question to ask, how much room for lawmaking by private judges, arbitrators, will government lawmakers allow? That's the plan, but before we get into it, I want to offer some special thanks. First, I'd like to thank my girlfriend or partner, Sarah McIntosh, who is a lawyer with Shook, Hardy & Bacon and has given me a lot of very good professional advice, along with so much else in recent years. And then within KU, I want to thank Provost Bickelmeyer and Dean Mazza, who lead the administrative work that universities and law schools need, which allow the rest of us faculty to focus on teaching and scholarship, for which I am grateful. And relatedly, I want to thank what I think of as the unsung heroes of law schools, which is associate deans. Dean Mazza was an associate dean, currently Kyle Velty, and before Kyle, Uma Alka. So big thanks to the associate deans, who I don't think get enough appreciation for the good work they do. And then on the law faculty, I want to thank three distinguished professors, Chris Strahosel, John Head, Rick Levy. Each of them helped me tremendously at crucial times in my career at KU. And as some of them move towards retirement, their good example motivates me to try to rise to fill their roles as helpers to law faculty. So we all sort of pay it forward to the next. And special thanks to the person who organized this presentation, the person in the provost's office, Yolanda Huggins. Yolanda did top-notch work at the law school on a huge variety of projects for many years. So totally understandable that when law professor Lou Mulligan moved to the vice provost, Lou would want Yolanda to make that move to that office too. And Lou is another person I thank for doing so much for KU, and we wish Lou the best in his new role as Dean of the Law School at the University of Missouri, Kansas City. So those are my thanks, and really thanking all of you for being here. But I want to go back to one person I thanked and tell a story about her, because it's going to transition into our topic of judges. And that person is Yolanda. Only once has a US Senator publicly cited my recommendation letter in voting to confirm a judicial nominee of a president from the opposing party. That nominee was now federal judge Holly Teeter, who was a top law student here at KU many years ago. Before I sent that letter recommending now Judge Teeter, I got input on a draft from Yolanda Huggins, who offered terrific suggestions that I followed because Yolanda is so wise on so many topics. And Yolanda's input made a better recommendation letter that seems to have helped a KU alum successfully navigate the Senate confirmation process for federal judges. And that Senate confirmation process is what I'm going to turn to on the next slide to get us deeper into our topic. With a quote from the Chief Justice of the United States, John Roberts, during his Senate confirmation. Roberts said something that I think is widely understood to oppose lawmaking by judges. Roberts likened judging to a baseball umpire, impartially calling balls and strikes, rather than trying to help either of the competing teams win the game. Baseball teams compete to win a game, and a baseball umpire is not supposed to favor one team or the other, but instead apply the rules of the game impartially. Similarly, with respect to law, we can think of Democrats and Republicans or other factions as competing teams trying to make the law advance that team's preferred policies. And according to this Roberts umpire view of judging, a judge is not supposed to favor one political team or the other by helping them move the law toward that team's preferred policies. Instead, the judge is supposed to apply legal rules impartially. So under this view, the various teams or factions in Congress and state legislatures can lobby and persuade and negotiate, and then whatever bill wins a majority of votes becomes law. And then when this law comes up in court, judges are supposed to apply it impartially, instead of expansively interpreting a law the judge likes while narrowly interpreting a law the judge dislikes. This view against judicial lawmaking is now on the screen, using the word statutes to describe laws enacted by legislatures. Judges should apply statutes impartially, not expansively interpret statutes the judge likes and narrowly interpret statutes the judge dislikes. That is, judges should set aside their policy preferences in deciding cases. This view against judicial lawmaking fits into a representative democracy with separation of powers. Representative democracy is we vote for legislatures and majorities there enact statutes. And then a separate branch of government, judges, impartially applies those statutes to individual cases. So that may be basically how the system is supposed to work, but the system depends on humans. And humans writing statutes are not able to foresee every possible dispute or case that's going to arise in the future. So statutory language can't address all those unforeseeable cases completely, which is going to leave gaps in the law, gaps judges have to fill as they apply that statute to new unforeseen cases. And sometimes legislatures purposefully write incomplete statutes because that's the only way to get a majority to pass the bill. So the legislature is sort of punting to the courts issues that legislature couldn't resolve, and now the judges are going to have to resolve. So either way, judges are going to have to make law as they interpret statutes and apply them to decide particular cases. This judicial lawmaking of filling gaps in statutes is routine and perhaps inevitable. So I'll quote here a sort of legendary expert in this field, Phil Fricke. Statutory interpretation often involves substantial judicial discretion and thus constitutes judicial lawmaking, not law finding. That's not my view. That's not Fricke's view. That's just widespread consensus and has been for a long time that judges make law as they apply statutes, and that this is just inevitable because of human limitations in writing statutes. Even more routine is judicial lawmaking through the common law. Big parts of important areas of law, like contracts and torts, remain unaddressed by statute, and so they remain governed by common law. Judges making law case by case is not new or unusual. It's been happening for centuries, going back to England, and big parts of the law still, common law, which we all agree, even Justice Scalia, opponent of judicial lawmaking, all agree is fine for judges to make the common law. So judicial lawmaking in both statutory and common law cases is routine and long established, and judges are human, so judicial lawmaking is sometimes going to reflect the particular humans who are making the law. Liberal judges tend to reach liberal outcomes, and conservative judges tend to reach conservative outcomes. Not in every case, perhaps not even in many cases, but in enough cases to make a difference. In cases where the law is ambiguous, judges consciously or subconsciously consult their own worldviews. There are now stacks and stacks of books and academic papers demonstrating that judges with different ideological views make different decisions in predictable ways. That's a great quote from Vanderbilt law professor Brian Fitzpatrick, who I think is here with us today. And I could have quoted many other legal scholars saying the same thing because, as Brian says, there are many, many studies to support it. So judges' ideologies influence the content of the law. And judges' ideologies are especially important in constitutional cases because although legislatures can override judges' statutory interpretations and judges' common law rules, legislatures cannot override judges' constitutional interpretations. That takes a constitutional amendment, and enacting those is hard, particularly at the federal level, but also in many states because of supermajority requirements. So judges' ideologies are especially important in constitutional cases, and also, as we saw earlier, often in statutory and common law cases too. All of which is to say, the importance of judicial ideology is why we have in our society, big judicial selection battles. Most famous is the US Supreme Court, where we see those hearings on TV and all over the news. And you can see here how close were the most recent Supreme Court confirmation votes in the US Senate. And it's not just in the US Supreme Court or other federal courts that judicial ideology leads to big judicial selection battles. We also see it in state courts. One recent example comes from my home state of New York, where the governor's nominee for the state's highest court was rejected by the state Senate. Although New York's governor is a Democrat and Democrats are the majority in the state Senate, the governor's nominee was rejected on largely ideological grounds, with more progressive legislators arguing that the nominee was too conservative on issues ranging from labor unions to abortion to criminal law. And these ideological battles over judges don't just happen in Senate confirmation votes. They also happen in states with judicial elections between opposing candidates. For example, just this week, a Wisconsin Supreme Court election had a clearly progressive candidate defeat a clearly conservative candidate in a race that attracted so many millions of dollars of ad spending that it broke the record for judicial election. And people cared about it so much because it decided whether progressives or conservatives would control that court, the Wisconsin Supreme Court, which matters so much for that state's law, but also matters nationally because Wisconsin is a swing state. So Wisconsin redistricting and election law matter to the whole country. So those are two examples of ideological judicial selection battles, one from each of the first two types of states listed here. New York's High Court is in the first category, like the federal courts, where the executive's nominee for judge has to win a confirmation vote in the legislature. And Wisconsin's Supreme Court is chosen in contestable elections, meaning two or more candidates can be on the ballot and the person with the most votes wins. In contrast is the third method of judicial selection, named the Missouri Plan after the first state to adopt it. And Kansas has a version of the Missouri Plan, so I'll explain the Kansas version. When there's a vacancy on the Kansas Supreme Court, people who want the job apply to the Kansas Supreme Court Nominating Commission, which then winnows down the applicants to 3 finalists and sends those 3 names to the governor. The governor must pick one of those 3 in 60 days, or the state's chief justice will pick one of those 3. So the commission's power to choose the 3 nominees ensures that the next justice will be one of those 3. The commission blocks everyone else from the court, so the commission is the gatekeeper to the Kansas Supreme Court. The commission being the gatekeeper to the Kansas Supreme Court leads us to ask, who picks the commission that then picks the Supreme Court nominees? And the answer is mostly the bar. The commission has 9 members, you see at the bottom here. 4 of the members are appointed by the governor, and then the other 5 on the right, you see, selected by the bar, people who license to practice law in Kansas. And you see the rough numbers here of about 2.9 million people in Kansas who during our adult years can vote for the governor, and the bar is about 10,000 people. Here's the national perspective on the bar's control of Supreme Court selection. On the left is Kansas, the only state in which the bar picks most of the nominating commission. But I mentioned how the system is called the Missouri Plan, and you see Missouri in the second from left column, which is almost the same as Kansas in terms of empowering the bar to pick a near majority of the commission. And then in the middle 3 columns, we have states that appoint their Supreme Courts, but with little or no role for the bar. And then finally on the right, states that have in their constitutions contestable elections for their state Supreme Courts. And we talked about ideological judicial selection battles in an elective state, Wisconsin, and a state with Senate confirmation, New York. But what happens ideologically in a judicial selection process like Kansas's that centers on a commission with members selected by the bar? In the contemporary United States, lawyers tend to be relatively progressive, and in nearly every state, more progressive than their state's voters and elected officials. As judges are nearly always lawyers, previous scholarship unsurprisingly finds that judges tend to be more progressive than their state's voters and elected officials. This is me summarizing data, campaign contribution and voter registration data, and the conclusions with that data from Brian Fitzpatrick, I mentioned earlier, and political scientists Adam Bonica and Maya Sen. Bonica at Stanford and Sen at Harvard. Here's their article. And to look in more detail, if anybody wants to, at the sort of methodology of their database, it's called DIME, Database on Ideology, Money, Politics, and Elections. The principal investigator is Adam Bonica at Stanford, so you can just Google Bonica and DIME if you want to dig into this more. And basically what their data shows is what I had on the previous slide, and I'll give the sort of punchline that Brian Fitzpatrick gives, which is that in nearly every state, judges tend to be more progressive than their state's voters and elected officials. And Fitzpatrick refers to that as the leftward judicial skew of the state. Fitzpatrick's data show that the size of this leftward judicial skew compared to the state's voters varies according to the method by which judges are selected. The leftward judicial skew tends to be larger in Missouri Plan states, that is, states that privilege the bar with seats on the Judicial Nominating Commission, than in states in which judges are selected by elected officials or partisan elections. These findings support the straightforward hypothesis that a judicial selection process empowering a relatively progressive group, the bar, tends toward more progressive judges, while judicial selection by the voters or by the voters' elected representatives tends towards judges more ideologically compatible with the voters. We can dig into a little of the data from those political scientists I mentioned earlier. I've highlighted Kansas here around the middle of the screen, and you see attorneys and judges. Kansas attorneys and judges ideologically around the national mean, whereas Kansas politicians, and this data is from a few years ago, well off to the right, more conservative than the national mean. So a pretty big gap between the elected officials in Kansas and the judges and lawyers. And contrast that here with Massachusetts to show a state where the attorneys, politicians, and judges are all ideologically very similar to each other, all in Massachusetts well to the left of the national mean, but all very close to each other. So no significant gap, for example, between the politicians, the elected officials in that state, and the judges. And Massachusetts, by the way, is a state like New York, where the governor's nominee, there's a confirmation vote, and the Constitution of Massachusetts doesn't give the bar any special role in the nominating process. So here again are the three basic ways states select their judges, and we've seen that judges' ideologies matter in all three of them, whether that be through a confirmation vote, or an election, or by empowering the bar on a nominating commission. And as we saw earlier, judges' ideologies influence the lawmaking judges inevitably do. So those political teams we started with, each trying to make the law according to their policy preferences, try to get judges with their views selected in each of these processes. And these teams compete with each other at the higher level of determining which of these processes a state is going to use. So this is the point from my roadmap, that who is selected as a judge tends to reflect who has the power under the governing selection method. But these 3 bullet points only show the selection of government judges. So now I've added down at the bottom a 4th method of judicial selection, contract, which selects private judges. Private sector judges we call arbitrators. Arbitration is private sector court. Arbitration offers private sector alternatives to the government courts. Different arbitration organizations, like the American Arbitration Association or JAMS, are private alternatives to government courts, kind of like Federal Express and UPS are private alternatives to the government post office. People with a dispute can contract into these private sector courts by agreeing to arbitrate. But the more common path to arbitration is that parties who don't yet have a dispute put into their contract that if they do have a dispute, then it will go to arbitration rather than litigation in the government courts. And the Federal Arbitration Act instructs government courts to enforce agreements to use private sector courts. So if you and I have a contract, including an arbitration clause, and we probably hope we don't have a dispute, but if we do have a dispute, and then I sue you in government court, you can get that court to stop or dismiss my suit. So my only option to recover from you is to assert my claim against you in arbitration as we agreed by contract. And then if I win in arbitration, say if the arbitrator awards me $40,000 and you don't pay, then I can get a government court to enforce that arbitration award in the same way a government court's judgment would be enforced, ultimately by the sheriff or marshal. So leaving aside some exceptions, government enforces both agreements to arbitrate and the decisions of those private sector judges. But why do parties opt out of the government courts and into these private sector courts we call arbitration? And I'm going to sharpen that question with the fact that courts are subsidized by the taxpayer, but arbitration is not. So the disputing parties have to bear the full cost of arbitration, but not the full cost of litigation. This quoted passage is from an article written by me and my KU colleague, Chris Strahosel, who I think is here with us. Chris is phenomenally productive and successful arbitration scholar, and just a big part of why I've so valued being at KU. And as you can see, Chris and I asked why, despite the government subsidy for litigation, some well-informed or sophisticated parties nevertheless choose to pay for arbitration. What is it that arbitration offers parties that they're willing to pay extra for? And among the commonly cited reasons Chris and I saw, the first one, arbitration may be faster and cheaper than litigation, and cheaper because of lower legal fees. So the basic idea is that arbitration tends to be a less elaborate process than litigation. Arbitration tends to have simpler and lesser pleadings, discovery, motion practice, rules of evidence, appeals, all the things lawyers deal with in litigating. All those things tend to be less elaborate in arbitration, so typically parties can have lower legal fees. Also, arbitration, you can see in numbers 2, 3, may lessen punitive damages, aberrational jury verdicts, class actions, and so forth. And as you skim through the rest of this list, we might see an ideology coming through, which we might call a commercial ideology or a business-like ideology. The Chamber of Commerce probably likes this list more than other interest groups do. So who are the private judges, the arbitrators, selected pursuant to the arbitration clauses in businesses form contracts with their customers or employees? I'll use Uber as an example, Uber app on your phone. If you've used that, you probably have an arbitration clause. We can imagine lots of Uber customers who may not even know there's an arbitration clause in the contract because the consumer hasn't read it. Or we can think of a business's form contract with its employees requiring arbitration, which the employee may not want or understand, but the employee wants the job enough not to walk away from it because of an arbitration clause. If those arbitration agreements are selecting private judges with a more commercial or business-like ideology than the average judge, government judge, or juror has, then we can see that private judicial selection, selecting arbitrators, also reflects power in the selection process. It's just here, it's the power of contract in the private sector rather than the political power of selecting the government judges we saw earlier. We saw earlier that judicial ideology, judges' ideologies, influence the inevitable judicial lawmaking. Will we say the same thing about arbitrators' ideologies? Do arbitrators' ideologies similarly influence lawmaking? We might say yes, because lots of evidence that many a party to arbitration tries to get an arbitrator likely to rule for that party, much like many a party to litigation tries to get a judge or jury likely to rule for that party. Forum selection, gamesmanship, you have all kinds of names for it. On the other hand, we might say that arbitrator ideology, unlike judicial ideology, does not influence lawmaking because arbitrators don't make law. That is, we might say judges' lawmaking is they're making rulings that will serve as precedents guiding future cases involving other parties. Whereas arbitration, by contrast, traditionally produces only one-off decisions that the parties to that case keep confidential to themselves, so they're not published decisions or available to guide other parties. However, some arbitration decisions, we call them awards, are published, and others, although not published for the whole world to see, may be available within the group that has agreed to arbitrate, such as members of a trade association. And I give examples: National Grain and Feed Association or New York Diamond Dealers Club. These trade associations, their arbitration systems are the classic example of a private lawmaking system. And this trade association arbitration can privatize all three of these aspects of lawmaking. First of all, the statute, because trade association arbitrators often apply their own trade association's written rules rather than government statutes. And then trade association arbitration can privatize the common law, because instead of following government courts' precedents, trade association arbitrators learn and try to follow each other's precedents. And then finally, this sort of arbitration can privatize the enforcement of arbitrators' decisions, because instead of parties going to government courts to enforce their decisions, the decisions are typically enforced through private sanctions, such as publicity of a member of an association who is not complying with the arbitrator's decision, or even threatening to expel from the trade association somebody who's not complying with the arbitrator's decision, which could end the business of that party. So we can think of these trade associations as like little commercial subcultures with their own ideology reflected in their own statutes, their own rules, and their own judges or arbitrators lawmaking. And then pulling the camera back to the big picture question leading towards where I'm going to end with this big question. Suppose a member of a trade association asks a government court to enforce an arbitration award made under private law that is contrary to, conflicts with the government law. Would government courts enforce arbitration awards applying private trade association law rather than government? You see, I say law on this is not well developed. And I think it probably depends on what is the government law that the arbitration is trying to avoid. We can contrast a sale of goods between merchants, where I think government courts would be more open to allowing arbitration replace the government law with privately created law, versus, for example, employment discrimination statutes, where I very much doubt courts would permit arbitration to replace the government law with privately created law. So private lawmaking by arbitration systems, I think, raises the grand question of the extent to which parties' freedom of contract allows them to replace government law with their own privately created law. Or conversely, the extent to which government law will restrict that privatization, either to protect vulnerable parties to arbitration agreements they don't really want. I give the example of employers saying you're fired unless you sign this arbitration agreement, or to protect public values, using the language of this argument, from people segregating themselves into their private gated communities. Here's the pro-privatizing vision I wrote many years ago, and I'll leave you with this. Arbitration can produce a sophisticated, comprehensive legal system. Even better, it can produce many such systems. The law, including the unwritten norms, the written rules, and the decisional law of, I just made up, the Widget Dealers Association, may differ from the law of the Gadget Dealers Association. And both may differ from the laws of the Sierra Club, the Alabama Baptist Convention, the American Association of Retired People, the Rotary Club, or the Saab Owners Association. So someone might be a member of a few of these groups. And if they have a dispute with somebody who's a member of one of these other groups, well, then they'll arbitrate under that organization's rules with that organization's arbitrators. But if your dispute is with somebody who's a fellow member with you of one of the different groups, then you'll be arbitrating under that group's law. This vision is that there's diversity among these different groups' laws, because what's best for some is not what's best for the others. But there's also a process of experimentation in which lawmakers learn from each other and copy laws which seem to be working better. And there may be even open competition among lawmakers to earn money by producing better laws. A market for law develops. And if it works well, this privatized system produces better law than does a system in which government monopolizes lawmaking. So that's the pro-privatizing vision, and the question I mentioned I'd leave you with is, would government lawmakers permit this growth of private lawmaking to happen? So with that, I thank you very much for your attention, and I look forward to questions and comments.
Thank you, Steve. Excellent talk. I am Stephen Mazza. I'm the Dean of Law School. It's my honor to be here and to moderate the Q&A. A couple of ways you can ask a question. You can put it in the chat, or you can raise your hand electronically, and I'll do my best to call on you. While you're thinking about questions that you may want to ask. I do want to take a moment, thank all of you for being here. I see a lot of my faculty colleagues, our members of our alumni base, scholars from other schools. Steve has been a distinguished professor for a number of years, and I don't want anyone to think that the delay in this lecture diminishes that achievement in any sense. There was COVID, and it put us off of a lot of our events. But again, it does not, certainly does not delay the significance of this honor or reflect the fact that Steve does not have anything but an outstanding reputation and well deserving to hold among the highest honors that can be given out to a scholar at the University of Kansas. Okay. Questions? Ben.
Thanks, Stephen, and thanks, Steve, for a really excellent talk. I really enjoyed it a lot. I am curious whether you can say anything about differences among states in terms of being welcoming or hostile or facilitating or resistant to various kinds of arbitration law or development of private law, or is it just kind of a federal matter because of the federal law that you mentioned earlier?
Yeah, you nailed it with your last point there. And I'm looking at Sarah Cole smiling, and I know Chris Hosel would have the same knowledge that the Federal Arbitration Act has so thoroughly preempted state law that we don't have diversity on this area of law that I'm suggesting fosters a lot of diversity, or could foster a lot of diversity within private sector lawmaking. So it's a terrific question about how nationalized the law on privatized law is.
Sarah.
Hi, Steve, and thank you for that talk. It was really interesting, and you'll see that one of your other friends, my husband Doug, joined me, and he's now a federal judge. So he had a question, I have a question, but I'll let Doug ask his question first.
So yeah, interesting talk, Steve. I was interested by the dichotomy you suggested at the end between private law and public law, and the extent to which judges would enforce private law decisions in the context of enforcing arbitral awards, and the suggestion that arbitration leads to private law governing rather than what you called, I think, governmental law. But I guess I wonder a little bit if that's right. I mean, it seems like whenever parties write a contract, they're essentially adopting a set of private rules, or what you might call private law, that's going to govern the relationship between those parties. So maybe a difference between arbitration and litigation might be the extent to which you need to expressly incorporate all the different sort of understood norms of whatever group you're in. And if you're going to have arbitration, you can rely on the fact the arbitrator is going to be familiar with those norms, whereas if it's going to be a judge interpreting the contract, you may need to be more express about them. But I don't know that that leads to a difference between government law and private law in terms of defining the relationship between the two. And with regard to your point about, well, is a judge going to enforce that private law? I mean, I think that isn't that really just sort of another version of the old default rules idea? I mean, sometimes you allow default rules to be changed. There are other default rules you don't allow to be changed. Some things you don't enforce as a matter of public policy, even if they're written in the contract between the parties. So even if the parties want this term, the court says, well, we're just not enforcing that term. So I'm not sure I'm seeing entirely the distinction between arbitration and litigation that you were kind of laying out there on those fronts.
He hasn't read default rules versus.
Sarah is reminding me that Judge Cole, using the language of the article I wrote, mandatory rules versus default rules. In other words, yes, Judge Cole, I agree with you completely that what I have stated is basically the distinction between mandatory rules of government law that government will not allow parties to contract out of, versus default rules of government law, where government will allow parties to contract out of them. And so your point, if I heard one of them correctly, is just anytime a government court enforces a contract, it is to some extent enforcing private law, that the contract terms are private law. What arbitration does, and I tried to articulate with the trade association example, is that it's not just a contract term where you read the words on the contract or you imply what's there, but it's an agreement to use a whole private system where the private law-making trade association, for example, is writing its own statutes. And then those private arbitrators are creating their own case law, building off those that may differ from what, say, an Ohio state court or Ohio federal court would do. How much of that privatized system is going to bump up against the government's mandatory law, where you say, no, we can't enforce this, versus when do you say, oh, wow, they've really developed a legit system here, we should let it go.
Sarah, did you have a question of your own?
Sure, I don't want to have the Coles dominate this, but I was curious, Steve, if you had, after doing all this judicial selection work, whether you had an opinion about which process, I don't know, better is the wrong word, but to the extent that we think judges' ideologies should have less influence over outcomes, is there a process of judicial selection that you think moves us towards that goal better than other processes?
Well, Paul Carrington was the dean of the Duke Law School, I think expressed this best, kind of like you said, I don't want to say best method of judicial selection. And what his phrase said was least bad of the various unsatisfactory ways to select judges is probably the one found in the US Constitution. And I think there's a lot to that, in the sense that it accepts judges are important lawmakers. So there ought to be a democratic element to the selection process, but having it be the indirect democracy of the other two branches, executive and legislature, as opposed to the direct democracy we just saw in Wisconsin, for example, recognizes that when judges are making law, they're doing so in the context of individual cases with real parties. And so there's so much to the impartiality point there, where we have suspicions about campaign contributions and other connections between judges and parties with cases before those judges, or lawyers who have contributed to the campaigns of those judges, etc. So I think there's a lot of blending of, yes, we want democracy, but we don't want too direct democracy in the selection of judges.
I'm going to go to John Head, and then Thomas will get you as our final question.
Yes, thanks, Steve, for your presentation. I wonder if first, before I ask my question, if I could make a suggestion that you end the screen saving, if that's a possibility.
Yes, if I can get to it. Thank you.
Or if somebody can. So my question is sort of related to what seems to be this distinction or balance or dichotomy that you're drawing between private law that is made, for example, by trade associations, and public law or government law. It seems to me that they're very different things in terms of the scope of their coverage, because trade association law or any other sort of commercial law that would be relying on arbitration for the settlement of disputes surely would not cover a great many topics that public law or government law does. For example, criminal law or property law or family law. Am I misunderstanding this somehow?
I think you've described what is, but not what has to be. For example, family law be an example where there are religious arbitration systems dealing with family law matters. And those have been some of the most controversial examples of that big picture question I asked of to what extent will government lawmakers permit this privatization, where different religious arbitration, divorce or other family matters, then being challenged in government court. So the boundary between, as you said, public law covering some things that private law won't reach to, and if private law stays commercial, that's relatively uncontroversial. Really, the question is how much can arbitration expand into what you or others might think, hey, this has to be public.
Thank you.
All right, Thomas.
Hi, Steve. Congratulations on this professorship. Wonderful news. The question that I wanted to ask is about the skew that I perceive of who gets to become a judge. Often, it seems to me judges have government experience, or if they come from private practice, they're litigators. But it's quite rare, for example, for a trust and estates lawyer to become a judge, or a business lawyer, or a tax lawyer, unless being appointed to the tax court, for example. John Langbine, who was on the faculty of Chicago when you and I were there, wrote an article with the wonderful title, "The Supreme Court Flunks Trusts." And the gist of the article was that there are many bodies of law, including trust law, that courts staffed with people who don't know much about it don't seem to be able to handle very well. And I wondered if you thought there would be less pressure for opting out of government judging if government judges had a broader swath of expertise.
I think, Tom, you make a terrific case for arbitration there. In other words, part of what's happening is that parties opting into arbitration are opting for what they think are more expert, specialized decision makers. And whether that means government courts should try to adapt to meet that competitive challenge from the private sector, that's a policy question on which I've seen different views. Chris Strahozel's written a terrific article on business courts. Many states have tried to compete with commercial arbitration by creating little subsets of their court systems with that expertise to compete. You might think of probate court as trying to compete with expertise there. I don't know how successful you would think those judges are, family law divisions, etc. So I do think that idea of specialization versus generalist plays a role in the competition between the public and the private adjudication. Very well said, Tom. Thank you.
Well, thanks everyone for those wonderful questions. Before we conclude this event, several of Steve's colleagues would like to make a toast. So I hope that you will join. Rick Levy, why don't we start with you? Rick there?
I am here. I was just trying to get my technology to work properly. Well, so it's a great honor that Steve asked me to be one of his toaster on the occasion of his inaugural lecture. Steve and I have been friends since he joined the faculty in 2003. And I think in this respect, we are evidence that it's possible, even in our age of hyperpartisanship, for people at different ends of the ideological spectrum to be and remain friends. So if you were paying attention to Steve's talk, you probably have a good idea where that places me on the ideological spectrum. In our time together, I've come to realize that Steve really epitomizes what it means to be a lawyer. For example, Steve embodies meticulous attention to detail. And I mean meticulous. If anybody here has served on a committee with Steve, you know that you can count on him to make you fly spec all the language in the committee's work product. And I think even in the law school, among other meticulous lawyers, sometimes people find Steve's attention to detail a bit annoying at times, especially because he always has a point. Likewise, I think you can count on Steve to challenge your premises. Always challenge your premises. It really doesn't matter what the subject matter is. Steve's going to force you to defend yourself. That is to say, I think Steve at his core is a contrarian, which is probably what makes him a good lawyer. It also makes him, I think, a great colleague. I love giving Steve drafts of my work for comment because I can count on him to point out every gap in my logic, every unsupported assertion, every unimported assumption, every unrebutted counterpoint, and every questionable conclusion. Once I get over the frustration, I usually find the finished product is better because of his input. Likewise, Steve and I have had many conversations over a host of subjects over the years, and we deeply disagree on many things, like the proper method or the best method of judicial selection. I enjoy watching soccer. Steve can't understand why. Steve enjoys watching baseball, and I can't understand why. So in all these conversations, we've disagreed a lot. I don't think we've changed each other's minds, but I know he's forced me to think more deeply, to articulate my positions more carefully. And notwithstanding our differences, I think Steve and I have a lot in common. I think we both believe that principle and facts matter. I think we both value legal scholarship and gain deep satisfaction from our work. I think we both work hard to help our students learn and to become outstanding members of the legal profession. And I think we both care about and are deeply invested in the law school and the university as institutions. So in the end, Steve has been a good friend to me in difficult times. I hope I've been a good friend to him. And I offer a toast on the occasion of his inaugural lecture. Thank you.
Thank you, Rick. I've enjoyed all of our lunches and beer after works together.
Thank you, Rick. I don't see Brian Fitzpatrick on the call. I just want to give an opportunity. All right. Well, then, Professor Cole from Ohio State, we're going to have you give the wrap-up tips.
Oh, thank you. I'm so pleased to be here today and to be involved in celebrating Steve, who deserves all the celebration and that he can possibly have. He's been a tremendous friend and colleague to me. I've been very fortunate that I met Steve along with several others on the call back in our small section in law school. And little did I know that we would end up in the same field and even more narrowly and actually in arbitration. That was never a plan. What I say about Steve is he's the way you see him today is honestly the way I saw him when he was in law school. He was a kind and thoughtful person. He was whip smart, but he would never say so. He was very modest. But little did I know that this baseball-loving libertarian and I would both end up in the field of arbitration. And our timing was really good because in 1991, a year after we graduated, the Supreme Court decided you could arbitrate statutory discrimination claims, and the arbitration field exploded from that point, giving us so much to think and write about. And then we have online arbitration and online dispute resolution that have continued in that way. Steve is a little farther to the right than I am, and as a result, I think was I don't know, the whipping boy for many of our liberal colleagues in arbitration. And he was never he was never thrown. He was kind and receptive and thoughtful. And so he was at so many conferences where he was the sole voice of freedom of contract. And again, just always looking confident and unflustered in his viewpoint, even when everyone else in the room disagreed with him. But of course, I'm here to tease him a little bit. And unfortunately for him, I have 2 boys and they've watched some pretty raunchy roasts. But no, I couldn't do that. I actually reached out to Bruce and Tom, who are on this call, because as I started thinking about it, I thought he's just always so unflustered and thoughtful and kind. I was just struggling to find what I could make fun of him for. So I'm stretching a little bit here, but I think I can make a little fun of his baseball. I don't know if it's an obsession to go around the country to see every stadium and I think every team in every stadium. And I think that Bruce, who's on this call, told me that it doesn't count if the team changes stadiums. You have to go back and see the new stadium too. So that's a good, I think at least a very positive obsession, but I think I'd put it in the obsession category. And I personally observed on Facebook his love of Settlers of Catan. I hope I'm pronouncing that correctly. So much so that I felt I had to buy it and see what this game was all about, because it must be good if he can spend this much time playing it. And then finally, I'll steal a story from Bruce Adelstein, who's on the call. And he remembered that when Robert Bork came to speak at our law school during Q&A, Steve noted that when Bork was younger, he considered himself a libertarian, but later changed his mind. And apparently Steve, I don't remember this, but Steve asked him what changed his mind, and Bork replied, "I matured." So most people laughed, but not Steve. Our kind, good-hearted, thoughtful colleague and friend is still a libertarian, as you know, so you can all draw your conclusions about his level of maturity. But from where I sit, let me toast and roast my amazing classmate, colleague, scholar, and friend for so many years for his past and what I'm sure will be tremendous future accomplishments too. Well done, Steve. Congratulations.
Thank you so much, Sarah. You and I have been friends for 36 years, and I'm really hoping we can do another 36.
Yeah, that's tough because I'm 37, so that really doesn't work out your math, but that's okay.
Thank you all so much for being here. I wish you all a great Friday evening as you head out into this beautiful weather. Stephen, are there any more final steps?
Well, we were hoping to get a picture. Now that is beyond my technical capacity. So Mary, are you going to help us with that?
Yeah, Dean Mazza, let me step in and help with that. If I could invite everyone to go on screen and bring up your videos. As you're doing that, you might kind of double check, find your best, right? Your best side, your best angle. And here in just a moment, we'll take about 3 different shots, all celebrating our distinguished professor. All right, everyone, on 3, 1, 2, 3. And let's try another one on 3, 1, 2, 3. Okay, very good.
Think we got it?
Got it.
Well, thanks everyone. Thank you so much for being here this evening. And again, congratulations, Steve, on this wonderful achievement.
Thank you all.
Thanks for being here, everybody. So Steve, what are you doing to celebrate?
I want to take advantage of this beautiful spring weekend and get in the yard and get my hands dirty. Have you planted anything yet this year?
I'm still cleaning up leaves. You know, I'm in a neighborhood with a bunch of oak trees. Not on my property, I should say, but on my neighbor's property. And I don't know whether it's because I'm on a curve, but I can rake all through the fall. And in the spring, I still have to go out there and fill up. You know, I probably do 30 bags in the spring.
You don't use a lawnmower to mulch them up?
Well, you know, I don't really have much of a lawn. I would, but they all go to the corners and, you know, so that's what I'm looking forward to it as well.
Yeah, let's get out into this beautiful weather. And again, Stephen, thank you so much for doing this. I really
Oh gosh, not at all. Glad to do it.
You're awesome. Take care.
All righty, have a good one.
You too. Bye-bye.
Bye-bye.